Thanks so much for chatting to me today. Obviously, as I mentioned to you, some of the guys after our webinar asked me a little bit about the living annuities, and I thought, let's have a quick chat. It might be a 5-minute chat, it might be a 10-minute chat, it might be a 30-minute chat. Let's just see how it goes. So, obviously, the appeal court did something very, very interesting in their judgment, May 2020, CM versus EM. The neutral citation 1086 of 2020 ZASCA 48. And what they decided in this case was that your future annuity income stream from a living annuity can constitute an asset for purposes of calculating an accrual. Now, obviously, this can become problematic, and I think where I'd like to go with our discussion today is to get a better understanding of what is a living annuity, how do they work, what are the pitfalls, what are the different types, and hopefully we can shed a little bit of light from a financial advisor's perspective for the rest of our mere mortals who don't always understand this stuff. So thank you so much, Jacques. I think let's start over here. What is a living annuity at the end of the day?
Mervyn, thank you. Just from our side, before we start, let me just say thank you again for the session we had the other day. It was absolutely remarkable to sit and help other people to understand just the complexities of all of our industries and where they come together. So yes, living annuities, and I like how you say where the mere mortals don't understand this, and I'm going to say to you that in some cases, even as financial advisors also have to go back and read the fine print to remember what it's all about. But it's a good thing, and I thought just in preparation for today's session with you, I thought I was going to spend some time and just kind of sit back and just maybe give you a simpler way of looking at what annuities are from that perspective, just so we can kind of really understand. And thank you very much for the light reading that you sent me of the CM versus EM case. I don't have all the specific case numbers on that, but it was very eye-opening to see how the courts have been looking at these types of products and with the judgments that they've given now. And I really have to agree, and I think the court really did a very excellent job in terms of understanding the products and what it's about. So, right, let's break this down to what you were asking me for. What is an annuity? So an annuity, simply put, is an income stream for the client, going from a specific point where they've decided to now go on to pension or retirement into one of those types of products. The product is designed very simply to provide income and income only. That's the simplest way of putting it for you from that side.
Okay.
Generally, they are broken down into two major categories of types of annuity. So the one you'll hear quite a lot of is called a living annuity, or it might be referred to as an ILA, or investment-linked living annuity. Right? Very simply put, that is a sum of money that's kept on a LISP platform. So that's a linked investment service platform that provides the holder with a value equal to the returns that money makes. So which means they can draw down on some of that money, and on an annual basis decide what the income will be. Right? So very simply, the client, whether it be mom or dad in the relationship, have the decision, husband or wife have the decision of what investment funds that they want to use to generate an income for them based on their risk profile. And they have the ability to choose what drawdown they take, i.e. how much do they want to draw down on an annual basis. And that is all it really provides. Sure. So it gives no guarantees in terms of longevity. It gives no guarantees in terms of investment performance. It is up to you as the policy holder to decide what investment funds you want to use to ensure that you have enough growth so that you have enough money to draw down without impacting the capital amount that was put into that. The second type, and we discussed this before, is what we call a guaranteed annuity. Now, a guaranteed annuity is pretty much an older style product, older generation product that is specifically there to provide with what it says, a guarantee. So irrespective of what happens in the markets, irrespective if the dollar goes down to 3 Rand a dollar, we would all love that, or goes to 75 Rand a dollar, it will provide X Rand that you have contracted for. So that is, so all that you're doing is you're effectively fully and 100% transferring the risk over to the insurer for the investment performance, as well as the longevity of that product.
Yeah.
So if you live to be 66 years old after retiring at 65, the insurer wins. If you live to be 182, the insurer loses because they have to ensure that they can provide that income while you are still alive, because that is the guarantee that they've delivered.
That's very interesting. So the guaranteed annuity, as I understand it, is much more aligned with the classical, in inverted commas, view of living annuities, where you have a capital investment which is basically ceded to the insurer, isn't it? They become the owner of the capital in exchange then for the annuity income. Is that an accurate way of looking at it?
So I think we need to make a differentiator here, Mervyn. The word annuity and capital and income are used interchangeably in these types of products. And I think a lot of people get confused between when it's a guaranteed and when it's a living annuity. There is a really massive difference from a financial planning perspective with the two types of annuities. But the simple understanding is, because you're taking a guaranteed annuity, I take my capital that I've raised throughout my savings journey. So let's just, for argument's sake, say I have R1 million. I take my R1 million retirement savings and I don't seed it, I give it to the insurer. And for that, I actually purchase an income stream back from them. So that's all I've done, is I've purchased an income stream. That capital is gone. It doesn't exist anymore. It now belongs in the books of the insurer. And this is on a guaranteed fund. Please understand it's on a guaranteed annuity. So they will have all of these very clever people and actuaries and product specialists, and they will actually run through mortality tables. And then based on that, they have a different payout to different people depending on their sex and their age. So very simply, unfortunately, us males do not live as long as females do. So generally, we'll receive a little bit more of our money in a just general perspective from that side. But ultimately, it is determined by the insurance company, and the insurance company has the money. You have only purchased an income stream. You have nothing more. There's no asset. There's nothing involved with this whatsoever.
Well, that's interesting, because that's really where CM versus EM went, where Judge Meyer or appeal Judge Meyer said, well, you have to distinguish between the capital, because there were previous cases that dealt with this capital. And I think quite rightly, they found that, the capital is kaput. It's not yours anymore. You give it over contractually to the insurance company. And as I understand the judgment, and please do correct me if I'm wrong, because I know it was a Sanlam product that was dealt with in this judgment, Glacier product, if I'm not mistaken, where Judge Meyer actually said, but hold on, that's only half the story. This capital is only one thing, but you can put a value on this income stream, which is a very, very interesting almost paradigm shift, in that one is used to saying, I have an asset in my hands, and therefore it is a value on my balance sheet. Whereas an income stream which you are yet to earn becomes quite a problematic thing.
Mervyn, it's very interesting. And I think the major differentiator here that we have to add into this is pre-retirement savings. And I mean, I think that's pretty clear from a divorce litigation story in terms of what happens with pre-retirement savings, right, versus post-retirement. Once post-retirement, you've reached that, and people then decide to get divorced. This is where it gets messy, and this is where it gets super complicated to try and distinguish between capital and an income stream and the asset and just something that you have somewhere. And it gets very, very complicated. And on this case specifically, and I was reading through that, trying to understand exactly how they plan to put a value on an income stream. Because the value of the
Yeah.
income stream, if the income is 10,000 Rand a month, as an example, exactly
Yeah.
how do I value 10,000 Rand a month? And
Well,
this
that's the
is very
question, isn't
difficult
it?
because I can't bring that in as an asset. Is it specifically an asset? And this is where the case goes about. It says to bring it in, and it's not quite clear exactly on what basis it is that they plan to bring that in. But they very correctly assess that the initial capital amount that was used no longer is owned by the client. The client doesn't have
Well,
beneficial use of that capital. The client has traded that beneficial use for an income stream. So actuarially, you probably could put a valuation that based on what the client's lifespan would be, but we would have to bring an actuary in for that and pay them for that. These services don't happen for free. So I would
well, absolutely.
probably propose that using that income stream as the client's salary, because ultimately that is what it ultimately is. That income stream, that pension that's generated from those annuities ultimately is there to replace the client's income when the client worked for a company.
It's a very interesting statement that you make there, Jacques, because that's in fact in CM and EM's case, that's what the full bench of the High Court actually did. And I think the quorum was, or the judgment was written by Keatley J. Who found, and I'm speaking under correction, I might be speaking nonsense and taking poor Judge Keatley's name in vain, but the understanding that I've got is that the High Court in fact said, but this is where it is relevant. It becomes an income stream. It becomes akin to a salary for a maintenance calculation. And the Supreme Court of Appeal then went and said, but hold on, this actually has a value in your balance sheet as well. And one of the criticisms which I've got from a number of colleagues to this case is specifically that thing that you highlighted there. How do you value this? Is it going to become a crystal ball exercise? And how can it be anything other than a crystal ball exercise? For example, on an accrual where they value this as being R1,000,000 asset for argument's sake, and you're getting 10,000 Rand a month. Now you pay out 2 million or R1,000,000 Rand towards your accrual. Let's say you pay out 500,000 Rand. And after 2 months, the spouse who paid out the accrual or the ex-spouse passes away. After having paid 500,000 and only having received a 20,000 Rand income from it. So I think this judgment is capable of criticism as far as that's concerned. And I think in a large or to a large extent, it creates more questions than it really answers, doesn't it?
Well, Mervyn, I hope that the audience understands that when it gets to this very technical point, you need to call in help. This is not something that correctly, as us mere mortals, will be able to sort out. I know in the CM versus EM case, they used a certified financial planner, they used an actuary, and they used a product specialist, as well as the provider's legal advice to help them and guide them to get to this decision. It is a major issue for me in terms of trying to place a lump sum value on an annuity. Because the annuity, and especially on a guaranteed annuity, the client has got no way of accessing that money to be able to give his spouse and let it pay out, as we would with pre-retirement, where we have the clean break principle. So that isn't there in post-retirement. And I think you mentioned in our workshop that it would appear as if post-retirement divorces seem to be on the rise at the moment, which now means that at some stage we're going to have to sit down and figure this out. But right now, crystal ball is the answer. I don't have the
absolutely. And I mean, one can even see that paragraph 39 of the judgment, or the order specifically under paragraph 39 of the SCA full method judgment. The appeal is upheld with cost. The value of the respondent's right to future annuity payments in respect of personal portfolio living annuities from Glacier Financial Solutions, a member of the Solomon Group, is an asset in his estate for purposes of calculating the accrual. Then C is very interesting. The matter is remitted back to the trial court for the admission of evidence on the value of the respondent's right to receive future payments in respect to the living annuities. I think if one were quite cynically inclined, one could say, well, the appeal court lit this fire, but they didn't show us how to put it out. It kind of said, well, here I identify the problem and I go like Pilate and I wash my hands and I send it back to the trial court. And that I think is a very, very problematic thing, because at date of this chat, at least as far as I'm aware, there's no precedent on how this is going to be dealt with, because I agree with you. The problem is you are creating a fiction here. You're saying this is deemed to be an asset when it's not yet an asset that is accrued to your estate. If this is valued at 2 bar, and the insured life, as they would call it, passes away after a month or two, that's then there would be a gross undue benefit. And I think it's the other side of the evil, which the appeal court referred to, the unscrupulous spouse who just converts everything into living annuities quickly before they can get divorced, which, let's be real, it is something that we see, unfortunately. But in terms of, I think the adage goes, you throw out the baby with the bathwater, don't you?
Complicated. This is not something that we will solve in the next half an hour's discussion, but I think the principle behind this has to be that, especially for the mediators, to understand that the products themselves and the rules around those products are legislated from certain aspects. So we need to understand that retirement money and then the subsequent purchase of an annuity, whatever, is legally controlled by SARS, the Income Tax Act, the Pension Funds Act, to allow people to protect that money, right? Yeah. Spouses or people, and I think ideally protect them from their creditors, should we rather say that, not necessarily to protect them from a divorcing spouse.
Well, absolutely.
But ultimately, we if the High Court then allows people to access that money and access the capital that was there to draw it out for the other spouse to do as they wish, that then potentially opens up another can of worms for those types of products if it comes to creditors and people that you owe money to. So it becomes a big mess with this type of thing. I think we have to tread lightly, or anybody viewing this this broadcast has to just kind of tread lightly and kind of think, how do we sort this out in the easiest feasible way? Yeah. To my opinion, the money that was spent inside the product actually doesn't belong to the client anymore, because the client doesn't have the right to go to an ATM to draw the money out.
Well, absolutely. And the appellate division, or the SCA, agrees with that view. They also said in Maya J's judgment that it's gone. It's out of your estate. However, and I think this is where the consternation comes in, is they said, well, it's the capital is out, but the future income stream is an asset. And that I think is very, very problematic, in that we don't have legislation saying how to deal with this. We don't have a Section 37, I believe, the Pension Funds Act, which says, this is how we deal with pension funds at divorce. Here's the clean break principle. And it might be a different section, but the point remains, we don't have legislation saying this is how it works. But in any event, that's where we are. That's what the court says, and we must deal with it accordingly. What I would like to also ask you, Jacques, just before we run out of time, and I do appreciate your time and sitting down with me. I don't want to keep you busy until close of business, because I know you've got a lot to do as well with all these complex products that you have to unleash upon society. When does a retirement annuity or a pension fund or a provident fund How does this conversion from pension interest to a living annuity work? When does it happen? How does one make the election? I believe there is some sort of provision with a capital amount that gets paid out, and then the rest goes to the fund. Obviously, I don't know if it's an industry-wide thing or whether it's simply from insurer to insurer. But at the very least, if you can tell me how Sanlam deals with it, I'd really appreciate it.
Sure. It's actually very simple, Mervyn, from the perspective that it is an elective choice that the fund member makes. And that elective choice is something that they can elect to do after the age of 55. So that is controlled by the Income Funds, by the Income Tax Act, as well as the Pension Funds Act. Right. At that time, they then have the choice or the election to draw out a maximum of 1/3 of their funds into a cash side after paying appropriate taxes, which also kind of gets very complicated with all the little rules and subsets behind that. And then a minimum of 2/3 of that product has to be put into an annuity product to purchase an income going forward. Now, you can retire from a private pension fund, i.e. a retirement annuity or a preservation fund, or even a provident preservation fund that you might have from previous employers before you actually retire from your existing employer. All that does, it means that it gives you 2 income streams and then ultimately bumps up your income tax rate because your income now goes to a higher level. But this is a decision that fund member makes in conjunction with his or her financial advisor, and we will run through those options of looking at why we need to do that, etc., etc. Generally, the best benefit that you could have from a tax perspective happens after the age of 65 because our tax rates drop from that perspective. If our net tax rates drop after the age of 65. So even though you're allowed at 55, there isn't a specific tax benefit you have from that other than maybe just an income benefit that you can retain.
Sure. Very, very, very interesting stuff, Jacques. I really, really do appreciate your time today. Last question, and I think it's more of an opinion question. What is your best piece of advice from a financial advisor's point of view to people going through a divorce where there's issues like retirement annuities and or even living annuities if it is post-retirement divorce? What's your best piece of advice on the spot?
On the spot, I think would be nice to each other. I suppose it does depend on what level of animosity there is between the two parties. But ultimately, if they can try to avoid those products or try to split up those products, I think it would be a lot simpler. If you are able to purchase, or in a pre-retirement scenario, if you are able to, every party to the divorce leaves their own retirement sides or their own retirement funds to the side without touching them, that's a lot simpler to action from that side. But I suppose every case is unique to its own. And this is a very easy one, but ultimately is be reasonable about this. You know, what are the goals and aims of this? And then lastly, I'm going to say is absolutely get advice from a certified individual that has a massive amount of experience in pensions, pension funds, retirement products that can help guide you as the mediator and help guide you as the attorney from that side, just guiding in terms of what the product rules would allow or not allow, because every product is slightly different, does allow certain things, even though generally they are very similar.
Awesome. Jacques, thank you so much for taking the time to chat to me. That is Jacques Theron, 212 Blue Star, and you are a Sanlam certified financial planner. Is that correct?
I am a certified financial planner, correct, and I work with Sanlam, yes.
Awesome. Jacques, thank you so much for taking the time to chat to me. I will let you know once we...